Okay, great.
Hi everyone, and welcome to another one of our webinars. This is the exciting conclusion to a mini-series that started yesterday, looking at an introduction to property settlement presented by Caris from PL Community Legal Service. Can I begin this session by acknowledging the traditional owners? I'm on the south side of the Brisbane River, so I acknowledge the Yagara people as the traditional custodians of this land and pay my respects to elders past and present. Caris?
Yeah, thanks, James. So sorry to anyone who was here yesterday. I wasn't able to chime in here. So I'd just like to apologise to all of the traditional landowners, either from this country or, across Australia. The traditional landowners here are the Pinjarra people of the Noongar Nation.
Terrific. We've got people tuning in from across Australia though, so we acknowledge First Australians across the country. Always was, always will be Aboriginal land. We pay our respects to elders past and present, to any Aboriginal and Torres Strait Islander people who might be joining us today. Welcome. I might just take care of a couple of housekeeping things before I hand over to Caris to present on property settlements. There are a couple of ways that you can ask questions as the webinar continues. You can type a question into that questions box on the on your control panel, or you can press that button that looks like a hand. We'll see something that looks like your hand going up at our end, and we'll be able to unmute your microphone and you'll be able to ask a question that way. Encourage you to hold your questions over until the end of the session though. The technology isn't great for a conversational style, so Caris will present the slides and has left plenty of time for Q&A at the end. The PowerPoint presentation, we sent an email around about 5 minutes ago with a copy of a link to Caris's PowerPoint. You should also be able to access it from the handouts area of your GoToWebinar control panel. We are also hoping to record the session and make it available. Yesterday's session is already up on our website. Can be some gremlins in that process though, so no promises about that. I think the last thing that I'll say, and I know Caris will talk about this a lot, but I just want to flag from the outset that this that Western Australia has a family law system that is quite different to other parts of the country, including the way its family law court operates. It's a great model and one that we should be looking at around the country, and indeed we are in Queensland. It was a recommendation of the Not Now, Not Ever task force report into family violence to look at something that's more along this model. And so some of the things that Caris is talking about are peculiar to WA, and some of them are applicable to family law practice across the country. So that's an important thing to bear in mind as I hand over to Caris to talk more about an introduction to property settlement. Thanks, Caris.
Thanks, James. Okay, so yeah, thank you for coming to part B. This is going to be the sort of more court process oriented side of things. But just first off, what we're going to be covering today, you can see we've actually got part B down the bottom there, but we did get some questions yesterday that were pretty good, and I didn't have an opportunity to answer them because, I mean, for windfalls at least I hadn't researched that area to prepare anything for this, but I have now, so I've got something on that here. I've also got another sort of look at the jurisdiction because I touched on that yesterday in the context of the Family Court of WA's jurisdiction and the requirements to file in the Family Court of WA. And Alison actually had a question on the day, but she's also emailed through some more details, so we'll go through those. There were some other questions yesterday as well, which for themselves, a lot of them sort of related to topics today. So I sort of just, left everyone in suspense. So hopefully those will be addressed by today's talk, but if not, you can definitely ask questions at the end. Okay, so that's what we'll be looking at today in sort of brief. So to start off with looking back at what we looked at yesterday in part A, you've got the windfalls. So windfalls are generally considered to be a contribution to the marriage and not a special circumstance. Windfalls can include stuff like lottery wins. LexisNexis, interestingly, they provide an example which is rezoning of land, which dramatically increases the value of a property. And I think that's pretty niche, but I suppose if anyone ever comes across it, that could be something. Also, in the case of inheritance, inheritance can be considered a windfall. So when you're looking at inheritance, you're looking at when the money was received. If it was early on in the relationship and it's, possibly a long relationship, then it's probably, it's probably just been absorbed into the other assets of the relationship. So it's going to be a bit hard sort of, I guess, distinguish it from the other assets at that point. But if it's near the end, then the money and the property received can possibly still be defined distinctly from the rest of the assets. So for that, it'll sort of depend. And I guess that's obviously, it's working in the favour of the party who received that inheritance because, it was sort of their contribution. But when you're looking at stuff like inheritance, the courts also held in some cases that you can look at the contribution that the party who didn't receive the money or the property made to the deceased person. So one example of that was a case where the wife had been caring for the late mother, and it was the husband's mother. So then the husband received a lot of inheritance, but really the wife had sort of been doing a lot there too. So that sort of was taken into account. And then in the case of lottery wins, what's relevant is, a lot of the time people say, well, who purchased the ticket? But if you're in a relationship, then it's possible that that's just considered a joint contribution anyway, because you've both purchased the ticket, because the money wasn't necessarily one person's really when you're looking at it as part of the assets of that relationship. So what they said, there was a case called In the Marriage of RM and DZYK, and that was basically just saying that because the ticket's coming from the shared incomes of the parties, there's an argument that it's not really that one person's contribution. And as a result, the winnings could sort of be shared and just considered as part of the whole pool. But having said that, there was an interesting case, which was Alford and Alford, and that was where the court decided that the husband had solely contributed to the lottery win. What happened there was that the parties had been cohabiting for about 1 year, and then there were another 9 years before separation. But he won that 1 year after they cohabited, and then he kept the winnings in his account, and it stayed there until after the separation. And the parties had kept all of their financial affairs quite separate throughout the relationship. But I think that's more in the context of, how the parties were treating their finances for the duration of that relationship, which could have an effect on the assets and the split, I think, regardless of whether it was a lottery win or something else. But yeah, so there they decided that, really for that, it should sort of just be considered the husband's contribution. So yeah, so that was what I sort of found about windfalls. Hopefully that answers the question. I think the question itself was pretty broad. And then on to the jurisdictional requirements for de facto relationships. So I touched on that yesterday about the requirements that the Family Court of WA has. And someone had a really good on-point question about it, so I thought maybe I'd just include it in today's presentation so that we can all sort of have a look. So the question was, in this sort of example that I've got up here, where A and B have had a 9-year de facto relationship, A has $100,000 in their super and B has $15,000 in their super, and they don't really have any other assets. And 3 years of the relationship were in WA, and then the remaining 6 years of the relationship were in Queensland. Then A and B separate, A comes back to WA after separation. Can they apply in WA for court orders? And all those questions sort of on the right there. So if we have a look at the requirements again, you've got, the 2002 thing, which I'm just assuming, it's pretty safe to say it's after 2002 that they've been separated. And then you've got one of the parties is living in WA on the day of the application for orders being made. So A's come back to WA, they're living in WA, so that's okay. And then you've got the next one, parties residing in WA for at least 1/3. It was 3 of the 9 years. So yes, technically they've satisfied those requirements. So to answer the first question, yes, A will probably be able to apply to the Family Court of WA for orders. And if the scenario was dealt with in WA, what it's talking about there is the super split that we talked about with superannuation yesterday, and the fact that de facto couples in WA can't get super splitting laws. So this is much better for A than dealing with it over East, because this way B can't get to A's super. And And I think that was sort of the example with, you know, is that just and equitable? Is that okay that that happens? So that, yeah, I mean, that's probably how it would work. They could probably file in WA and it would be dealt with in WA maybe, but just because you can file in WA doesn't necessarily mean that it's going to be dealt with over here. So is it just an equitable? You know, probably not. From what we've got there, it looks a little bit sus, but at the same time, you know, there can be so many things that come into it and reasons for A to be back over here in WA and to need to file over here. So maybe, but yeah, definitely, you know, at first glance, that it doesn't look great. So then, is there anything stopping clients from doing that kind of forum shopping? I mean, there's nothing more than those jurisdictional requirements to stop clients from forum shopping, in the sense that if you satisfy those requirements, you can file in the Family Court of WA. But at the same time, I mean, possibly adding more strenuous requirements for the jurisdictional sort of thing, it would raise that bar higher, and then you might end up barring some people from applying in WA where it would really suit the interests of justice for them to apply over here. I don't really have an example of where that would be the case, but I guess, you know, they've probably set that bar somewhere sort of in between so that they're not excluding anyone who needs to come over here. But on that matter, we've got the last question there, which is about transferring matters from WA. So yes, the answer is you can transfer matters from the Family Court of WA to other courts. And so I had a little look, and I had to talk to the court as well this morning, because you've got Section 44 in the Family Court Act here, which is saying that you can transfer the proceedings to another court. So again, you know, we're getting really into the jurisdictional issues, which is quite a specialised area. It's quite technical and a bit hairy, but this is the section for transferring the proceedings to another court. There's another section there which is, you know, if you want to sort of hold the proceedings, so that basically, you know, WA doesn't keep dealing with it. If for example, you've got proceedings already over in the Family Court of Australia or in the Circuit Court, and then some crazy party over here decides that they're going to file in the Family Court of WA. So that's also an option. So I had a chat to the court about how you would go about doing that, because there isn't a specific form to use for it. And the reality is, if you're over there with your client and the other party is over here and they've filed for proceedings, they've done their application form, which we'll look at sort of later on in today's session, and you've now got to do, well, your client has to do the response documents. So what the court was saying was that what they think is that you should put it in your response documents in the orders that you're seeking an order for the proceedings to be transferred over to, you know, whichever court it is, the Circuit Court or the Family Court of Australia. And they're obviously not my specialty at all, so yeah, whichever one of those is sort of applicable. So that's how they said to do it. So we'll have a look later on today about, you know, response documents and what forms are involved in that sort of thing. But because it has been filed over here in the Family Court of WA, you would need to do those response documents and give them to the court here. Yeah. And so I guess something to look at there is that it's, you know, the subsection 1, you've got if it's in the interests of justice or of convenience to the parties. So in that kind of situation, maybe what you'd be arguing is it's in the interests of justice because the majority of the relationship is over East. And so one party has only just come back and is sort of possibly, you know, trying to abuse that. But yeah, I mean, how you would, whether that argument would be successful, how you'd phrase it to make it successful, I can't say, because I've definitely never, I mean, I'm a WA lawyer, I've definitely never made an application for anything over here to be transferred over there. All right, so back on to sort of the main part of today. We've got an overview here of the different pathways to reaching a property settlement. Because like we said yesterday, there's the whole go to court option, and then there's all those other options that can come about as well. So not all of the clients that you see who want advice in this area will want to or need to apply to the Family Court of WA for orders. Some of them, you know, where possible, they can resolve the settlement through consent orders, and yes, you apply to the court for the consent orders, but at least it's through agreement. So as you can see, down here, I don't know if you can see my mouse. But if you've got agreement, then you've got a bit more control over it. So that's better for the client, really, if they know what they want and if they can agree. Sometimes that's just not an option for clients, and we'll sort of look at that as well, because sometimes, as I'll say later, one party will just ignore the attempts to negotiate, and if you're sort of just trying to negotiate with a stone wall that's unresponsive, you're really not going to get far, you're not going to reach an agreement at all. So where that happens, as you can see with this diagram, there's really limited options with the no agreement. I mean, it's really a case of going to court as far as, you know, taking action rather than just sort of sitting back and leaving things as they are. So even where that's the case and there's no agreement and you're looking at, you know, going to court or helping your client apply to the court, it's really important to note to the clients that they can still come to an agreement with the other party anytime up until the judge or magistrate gives their final judgment. And so sometimes it's helpful, and I think I go over this a bit more later as well, but sometimes it's helpful in those situations where the other party is just not responding and is just completely ignoring any negotiation or letters or correspondence, because at least then it's in court and they have to respond. You're sort of dragging them kicking and screaming to the point where they need to accept that this is something that's happening and they need to, you know, come to the table and actually think about settlement options. So some clients are actually able to reach an agreement with the other party, and where that's the case, they might be coming to see you for advice on the potential agreement, or they might just not realise their options for the agreement. They might just be planning to leave it as is for sort of an informal kind of settlement. So you can see here they've got multiple options if they have come to an agreement. They can walk away, they can have the agreement made into binding court orders, or they can make a binding financial agreement. Usually for my clients, I encourage them to file for consent orders. It can be important because that ensures that the agreement's actually going to be enforceable in the future. People can change their minds, they can get upset by something your client does in the future. For example, if your client starts a new relationship, suddenly that informal agreement might fall apart. Or, you know, in the case of family and domestic violence issues, they can decide to be controlling or manipulative and to use those assets and their control of those assets as a weapon. So you really want to avoid a situation where you're placing your client in a position where that other party is going to be able to go back on their agreement and then sort of blackmail your client in one way or another to get something that the other party wants in exchange for actually holding up their end of the agreement. So sometimes a client will insist that they have agreed and that everything's great, but once you start talking about the consent orders, the other party won't be willing to turn that into consent orders, or they'll suddenly realise when you're trying to make things into orders, and we'll look at that later as well, you're trying to make it very clear, and some of the agreement is actually quite vague and open to interpretation. So usually, you know, if the other party is suddenly getting cold feet and wants to agree but doesn't want to turn it into consent orders, usually in that case I sort of try to encourage the client to be a bit cautious because of what I was talking about a second ago with, you know, the potential for the other party to abuse that, and a lot of our clients being victims of domestic violence and that sort of thing. You know, you don't want to create a situation where that can be perpetuated in the future. So consent orders are also really helpful because they can result in the nominal stamp duty, so $20, I'm pretty sure it is, for transferring properties between the two, and also some benefits for the capital gains tax. I'm not an accountant, I don't really understand a whole lot about capital gains tax, but there's benefits to doing it as consent orders. Having said that, I think nominal stamp duty, the $20 stamp duty, is also available for binding financial agreements. But I can't guarantee that because binding financial agreements are quite complicated. They're not something I've ever done myself. Basically, it's not done as court orders through the court. It's an agreement between both of the parties. They both sign it. They both get independent legal advice. So that's, I guess, the additional requirements and necessary legal costs. It needs to be set out well, and usually it gets drafted by a lawyer, so you're paying a lawyer to draft it anyway, and then both of the parties have to go and get independent legal advice. And then the possibility is that, you know, maybe if one party isn't happy with it in the future, they can dispute it in court. So because of all of those complications, I usually, you know, in most cases, I think consent orders will sort of get the job done for the client. It's possible that a binding financial agreement is better for some people, but generally for our clients, you know, there's, like I said, there's not a lot there in the first place, and there's a whole lot of other considerations around abuse and violence and that sort of stuff. So with the consent orders, I think we talk about it a bit later as well, but the court's only going to make consent orders if they think it's just and equitable, and that's that step 4 check. So for clients, if you're talking about the agreement that they've reached, you sort of work towards, you know, encouraging them to do the consent orders angle, and then if you're looking at this agreement thinking, my gosh, this looks really wrong, then that can be a good jumping point to say, you know, the court is going to look at whether these are just and equitable. And then sometimes you can go through the whole 4-step process and the considerations, because, yeah, I mean, even yesterday going through the 4-step process, a lot of the time when clients have come to me saying, oh, you know, this is what he's offered or this is the agreement, it's something really absurd, like, you know, the other party is keeping the house and all of the equity and the client is just keeping the car and their own really huge loan. Meanwhile, the client's going to go off with the children who knows where, because they're not going to have a house, they don't have any earning capacity. So it's, you know, it's not sort of a tricky one to figure out. It's quite clear when you're looking at this that, you know, it's pretty extreme. Yeah, so sometimes clients, you know, that they're happy because they reached an agreement. So it's kind of, it can be quite hard to sort of try to talk to them about whether that agreement is actually, you know, really just or equitable in their situation. Having said that, so that's the consent orders with the just and equitable, but the binding financial agreement doesn't have to be just or equitable because it's not going through that check process with the court. So there's no independent scrutiny. The parties are getting independent legal advice, but it's not a, you know, really about whether it's just and equitable and is this a good idea kind of thing. So generally, if a client's talking to me about, you know, the other party wants a binding financial agreement or the client's really interested in exploring binding financial agreements as an option, I'm going to refer them to a private lawyer or to one of the pro bonos that we have helping out, because it's more commonly something that the private lawyers are going to be experienced in. I wouldn't really be comfortable being the independent legal advice for a client who was signing a BFA. It just sort of seems a bit risky. So we'll come back to agreements again because we're looking at consent orders a bit later on, but just highlighting there's those other options there. The client can walk away. It's not a great idea. Some clients do take that option because it depends on the circumstances. For some people, you know, it's worth it just to get away, and, you know, maybe extreme cases of domestic violence and that sort of thing where there's not really much there anyway. But even then, you know, a lot of the time consent orders can be a really good idea. So there's also the BFAs. I'm not going to be talking about the binding financial agreements much, so sorry, but if you want more information on them, then there might be someone with more specialised knowledge who can do some training or something. Okay, so we've got an overview of the process here, which is if there's no agreement. And so we'll run through this process because, like I said, at any point along this sort of journey, the parties can make an agreement. And then you can end up with your client coming back to you saying, oh, we've reached an agreement now, this is what we think. So you've got the different steps there, you've got the pre-action procedures, and we're going to go through all of these today. And then you've got the application to the court, and then you've got the actual sort of court process itself. So if there's no agreement, then the first step before running off and filing things in court is to do the pre-action procedures. And that's the requirement. I think it's the same over there as well in other states. So that's basically a requirement that the parties just participate in dispute resolution, and then if dispute resolution is unsuccessful, you need to write a letter to the other party setting out the claim, exploring options for settlement, and providing a time to reply. Parties also need to comply with the duty of disclosure. And I've got some Family Court of WA brochures there. They're available on the Family Court of WA website, and they can be helpful, particularly in some cases where the other party is disputing, you've got a response from them, but they're claiming that they don't have to disclose anything, and it's all, their private information or something. So that can be helpful just to sort of highlight, this is something from the court, and it is telling you, you've got to give us some disclosure. So before dispute resolution happens, we sort of give our clients some tips around keeping themselves organised, listing all of their assets and liabilities and estimated values, getting copies of all of those tax returns and bank and super statements, keeping a copy of the documents that are sent and received, because otherwise sometimes you get someone later on in the process and there's been some negotiation happening in writing, in letters back and forth, but they either haven't kept them, or maybe their other lawyer didn't give them back to them, or they sort of lost them, which makes it sort of hard to follow through on what's been discussed. And then they can also keep a list for themselves of what's agreed upon and what's not, which can also be important, because there's a lot of clients who are trying to do that negotiation process, and it's usually by text message or something, and they agree upon something like the dining table, and then next thing you know, next week he wants something else. So now he's saying she can't have the dining table anymore. So they're just sort of going around in an endless circle of, really arguing over asset by asset, who's going to get what, which is going to take them a really long time to get anywhere. So yeah, so that can be helpful if they've sort of got some firm agreements, like, we both want to keep our own cars or something like that. And also organising everything chronologically, keeping it in sections. And these are just tips for them so that next time they come in to see you, if they need some more advice further on the process, you can sort of quickly have a look and get an idea of what's going on. Otherwise you get people coming in, they've just got a shopping bag full of, bits of paper. So half the appointment gets spent going through the bits of paper and trying to get them in order of what date things were sent and what's been discussed. Before you can even give them any actual advice. Okay, and so then you try the dispute resolution, and if that doesn't work, then they should be sending the other party a letter, and we've got an example on the next slide. So the letter should be setting out that it's without prejudice, should be providing a background of the relationship and contributions, listing the assets, liabilities, and the estimated values, giving a settlement proposal, and giving a request for disclosure from the other party and providing disclosure from the client, and then giving a time for the other party to respond so that it's not just open-ended. And so this is the letter here, and hopefully it's big enough for everyone to sort of see. We give this to our clients a lot of the time if they come to the settlement talks, and that's so that they can sort of, get an idea of what their own letter to the other party should be looking like. Because, a lot of clients are really intimidated by the idea of writing, sort of a professional letter. And so what you can see here is that we've got, what looks like a whole lot of the information that we covered yesterday in the 4 steps. So it can be helpful anyway, because even if the other party doesn't respond or this negotiation doesn't end up reaching an agreement, your client's still got it sort of neatly written down. Which can be really helpful, especially when there's a whole lot of assets to get through. So I'll just leave that up for a bit. So you've got, at the top of the right page there, they're showing the net assets that are available for distribution. So they're starting off on that sort of right track of saying, this is what the assets are that are available for distribution, this is the value of it for distribution, rather than sort of listing those assets over there on the first page and then suddenly trying to divide them item by item between the parties, which, like I said, can lead to that whole sort of going around in a circle of an argument about who gets what and then changing your minds day after day. So yeah, so that can be sort of helpful, encouraging the other party to sort of start off on the right track. And then, yeah, the duty of disclosure, and then as we can see there, it says, I've enclosed for your information a copy of the duty of disclosure brochure, just so that, if the other party's in doubt, they've got that there, they know that it is actually a thing they do need to disclose. And I will talk about disclosure, I think, in a minute, because there was a question about that yesterday. And so then they're giving a proposed settlement, they're providing their own disclosure up there, and down the bottom they're giving the 21 days to return with a response. And so that's really helpful for clients, because otherwise they're not sure how long they're supposed to wait for a response before they move on to doing something else. So for disclosure, parties need to exchange documents including, but not limited to necessarily, the 3 most recent tax returns, the current bank statements and superannuation documents. And obviously if there's, more assets, I don't even know, like trusts and businesses and that sort of thing, then, more documents are going to be required. But those are the basic ones. It's best to exchange them as soon as possible, and that's, for obvious reasons. It's going to inform the negotiations and make it easier for everybody to understand what is going on and what's in dispute. At the very least, it must be done, and we'll look at that in a second, must be done at least 2 days before the first court event. So the rules relating to disclosure for the Family Court of WA, which I was checking up on today in the context of enforcement, there's subsidiary legislation for the Family Court of WA, and that includes the Family Court rules and the Family Court regulations. But in the Family Court rules, you've got sections 12, 13 and 13A, and they specify that the family law rules, generally speaking, are adopted for use by the Family Court of WA. The 13A is detailing specific sections of the family law rules, specific rules within the family law rules which have, sort of an altered effect in WA. So it's not necessarily straightforward. And I think there were some regulations for the family law rules that were passed which also don't apply in WA. So it's not the most straightforward way of looking at things, but at least in terms of the disclosure, those rules should be the family law rules. I couldn't see anything in there that was sort of varying that, and the court's documentation was all referring to the family law rules as well. So in the family law rules, disclosure starts at about part 13.1. That's all about disclosure between the parties and the duties. So yesterday we had an interesting question about what happens if someone does not provide financial disclosure. And that is a common complaint in and out of the court, and it's something that I've seen sort of a fair bit with clients. You're trying to give them advice and they have no idea how much super this other person has or what company the super's even with. Ultimately, nothing outside of court is going to force that other party to give disclosure. There's nothing really there. I mean, the duty is sort of already in the legislation, but there's nothing outside of the court that's going to force them to actually do it. So eventually those people often, if they want to get anywhere and the other party isn't providing that disclosure, they're going to have to commence proceedings in the Family Court of WA. And if the other party still refuses to provide disclosure, then they can seek an order from the court that they provide the documents, the specific documents, usually sort of a list or, that sort of thing. Having said that, sometimes, and what I've seen a lot of, is that the Family Court of WA isn't interested in making that kind of order because the requirement to disclose is already there. So they're making an order for someone to do something that they already have an obligation to do. It's already required by the Act. But anyway, it's, it's still an order that's possible to ask for, I suppose. It's not one that I've ever had to do myself, so I can't really speak to the success or failure of asking for that specific order. Eventually, with, continued failure to provide financial disclosure, the possible consequences that someone's looking at is that the court will either not allow that party who hasn't disclosed that information to use the undisclosed information or documents as evidence in the case. And that sort of, makes sense. If you haven't disclosed it, then why would you get to bring it into your advantage? They might just stay or dismiss all or part of the case. They might make a cost order against the person who didn't disclose. they might fine or imprison the person for contempt of court, and I think we all know that's, you know, probably not the most likely option. Or in some cases they might just assume or assign a value to the person's interest in, you know, to any of that property that they haven't disclosed, in order to determine the net asset pool relationship so that then an actual property settlement can be reached. And, you know, generally the court's going to have to use its own discretion to do that, and that's probably going to be in the favour of the party who has provided disclosure. So if the other party hasn't disclosed their super or maybe some savings offshore and there's no way to sort of find that out, then the court might end up estimating that there's a higher amount there than what it actually is, because they just don't know. So hopefully that answers that question. That's sort of the extent of my knowledge of that one. So once you've sent that negotiation letter that we were looking at, or once the client has, the other party, you know, a fair bit of the time what I see, the other party is just completely ignoring all of it. So there's no response, or it's failed to actually get anywhere. Then it's usually recommended that they write another letter to the ex-partner setting out that, again, it's without prejudice, setting out the issues in dispute again, the orders that they'll be seeking, making a genuine offer to resolve the issues, and a time for them to respond again. So you're just sort of sending another letter, but this one is more in the context of, you know, this is what's happening, and, you know, I'm getting ready to seek these orders through the Family Court of WA. Just giving you some notice that, you know, this is where this is headed. And just to note there for clients, they need to always keep copies of the letters or the documents that they're sending. Some clients forget to do that, and then you can't tell what they've offered the other party. Alright, and so for these pre-action steps, there are some exemptions from those. So unless you meet one of these exemptions, you are going, well, your client is going to be required to follow through all of those steps that we've been sort of looking at. The exemptions include urgency, family violence, allegations of fraud, if one party has just refused to negotiate, if the time limit is close to expiring, or if the same matter has been in the court over the last 12 months. So it's, you know, there's a few options there. Doesn't necessarily mean that they're, you know, really easy to just call upon. Oh, and actually something I saw as well was something along the lines of bankruptcy possibly being an exemption, I think. That wasn't on this slide, so I haven't added it, but yeah, maybe something to be mindful of. Although again, bankruptcy in itself is going to be sort of very complicated in the context of a property settlement. Alright, so here I've got the Form 4, which is used to notify the court of child abuse or family violence or risk of those. So if you're trying to get an exemption on the grounds of the family violence, then you probably want to file one of these forms so that you're actually explaining to the court what the extent of that is. I don't have the other pages of the form, but basically it goes through the different sort of forms. So you can even see here in Part A, it's the child abuse or risk of child abuse, family violence, or both. So it can sort of relate to any of those sorts of circumstances. So even if it's just violence towards, you know, your client who might be the mother, or even if it's, you know, just neglect and child abuse, that sort of thing. And the other pages of this form go through a whole lot of, you know, questions and opportunities for the client to give information, which is why it can be a lot more helpful than just filing sort of the application documents, because there's more opportunity to sort of pinpoint what exactly the issues are if they use this form. And something else to note as well is that the form that's on the website, I think it's got some pages attached at the start as well, which is just some information about what's included in family and domestic violence. So that can be really helpful, you know, for people who are self-represented. But also it's just good to give them that to take away from the appointment, because you should obviously be giving them some advice on, you know, what is included in family and domestic violence. Some clients still do think that it is just the physical stuff. So you can advise them of that, and then they can take that away with the attachment, sort of explaining it to them as well. Alright, and then we've got the consent orders form. So if the parties have agreed at any stage, then they can apply to the court to have that agreement made into orders. So the form itself, this form is quite simple, but you can't forget Part E, which is the very important minute of consent orders. So some clients do actually file the Form 11 without the minute attached, and for obvious reasons the court can't make consent orders if they don't have a copy of the orders that they're meant to be making. So parties have to attach a draft set of consent orders. So the minute of consent orders, there is a form for a minute of consent orders on the Family Court of WA website that parties can use. And in that minute they're typing it up very neatly in sort of, terms of actual orders, what they have agreed upon. So sometimes that's the complexity if your client has come to you with an agreement, is how can that be reflected in actual court orders? Because sometimes, again, the agreements that they've made make sense to them, but they're not actually phrased in specific terms, or they're a bit vague and open to interpretation. So the consent orders can include agreement about the sale of property, transfer of land or interests, cash payments between the parties, or retention of the property. And that's what the minute actually looks like. So it's, again, it's fairly basic. It's just sort of helping clients who maybe don't have a lawyer to do it for them to just provide the parties details and then to start listing those consent orders down the bottom there. And so this is from the presentation that we give to the clients. So it's just some examples of what consent orders can look like, because again, like I was saying, some parties have these agreements that, might be in writing and they might be signed, but yeah, they're vague and they're not really phrased like a lawyer would phrase them, I guess, at the end of the day. So this is an example of selling a house, splitting the money, and you've given the address there, and then the important part is also giving the land description, which is on the certificate of title. And you do need to provide the certificate of title of that property generally, and that's so that the court itself can also check that the orders are being made about the right piece of property. Sometimes, yeah, attention to detail, some clients, they do get these sent back because they've given the wrong address or they haven't been specific enough. So that's just something to be mindful of. And then you've got the proceeds of the sale of the property to be dispersed. And there for A, B and C, you've got the other expenses that sort of come out before the balance gets divided between the parties. And there you've got the proportion division, but I guess, you could also have something there saying that, $7,000 from the sale proceeds goes to A and then the remainder goes to B. It depends on the circumstances and what's going to work and what's necessary, I guess, between the parties to make that happen. So then we've got more examples, and that's the transfer of the interest in land, and again you're being specific with the certificate of title, description, and then you've got assets other than land, and so that's just sort of a very general one there, which is, each of them are keeping their vehicles and the furniture and household contents. And that can really work in situations where the parties have sort of separated. They've already divided up the small stuff and they're really just trying to sort out this house. So that can be helpful sometimes. Other times, there might be more needed, but these are sort of quite straightforward. Oh, and I guess one other thing to be mindful of, especially with consent orders when you're sort of checking them or drafting them, is making sure that they're specific enough that they can actually be enforced if the other party doesn't comply. Because I have seen a client or two who's come in with some consent orders which finalised their property settlement. And the way that they've been phrased is sort of a bit broad, so it's going to be sort of a bit of a struggle for the client to get it enforced because it hasn't, it hasn't specified, when people are going to do things or something like that. So it's just easier to sort of, keep in mind that the other party might not comply as nicely as you might hope, I guess. So for no agreement, if the parties can't reach an agreement out of court, like I've been saying, the only option might be for the client to commence proceedings. A lot of the time for the clients that I see, the other party just ignores the pre-action procedures. They don't attend dispute resolution, they ignore the letters, whether they're from the client or from us, they ignore it all. So the client is really left with the decision of either, keep on trying to negotiate with this unresponsive person, leave things as they stand, which is obviously problematic if they've got a house together or, if they've got lots of debts that they need to sort out, or to commence proceedings in the Family Court of WA. So ideally, proceedings in the Family Court of WA should really just be for the larger asset pools and for the more complex stuff, but for smaller asset pools for our clients, sometimes that's all there is and the client needs it, and the only option is to go to court to get that, or to get the other party to the table so that they can, work on the negotiation and hopefully come to an agreement. But look, it's always worth encouraging the client if they are just sort of skeptical and just want to sort of bypass all of the pre-action procedures. Unless there is sort of a good exemption reason, it's a good idea to encourage them to, have a real crack at it, because it's much better for them to do it out of court and to save themselves the expense and the stress and the time of taking it through the court system. But yeah, again, like I've been saying, for a lot of clients, especially where there's a power imbalance and control issues, the other party might not come to the table until they're sort of forced to by the court proceedings. So while it's a last resort, it's used surprisingly often, from what I've seen, just to get the other party to participate. All of the forms that the client's going to need to commence proceedings are found on the Family Court of WA website. It also has some nice kits which can be helpful for clients who are doing it themselves. And there is a duty lawyer usually on level 3 of the Family Court of WA. So if the client sort of shows up for their first court date or is filing documents and gets confused, sometimes they can go up there and see the duty lawyer for a bit of last-minute help, which is nice. So for the application for property orders, clients are going to need to file the Form 1 initiating application, the Form 13 financial statement, which is part of disclosure. It gives a lot of information about the assets and all of that sort of stuff, and an affidavit in support. And as we've got there, it's best to type the forms. They can be neatly handwritten, except of course for affidavits, which that's going to need to be typed. And over here we've got the Form 1. So that's the Form 1 over here for the Family Court of WA. So it's fairly straightforward, but a lot of clients do struggle with, phrasing what the actual orders are that they want. They can tell you colloquially across the table, but when they actually have to write it down, it sort of gets a bit confusing for them. So some people need a bit of help with that side of things, but as long as the client has some idea of what they are going for, that can be helpful. There is a property orders kit on the Family Court of WA website, which has examples of different orders, and that can also be helpful. If you haven't got time maybe to do that with the client, you can send them off to have a look at those example orders, because some of them are, really quite helpful. And it does at least sort of show the client what those orders should look like and what they should sound like, sort of the language involved. All right, and this is the Form 13 financial statement. That's required, and that's where the client provides information about the assets. Most of the details that are required by disclosure are provided in this form. If further disclosure is required, then the client might need to file an affidavit with that. And if circumstances change, then you should update this Form 13 financial statement, generally within 21 days. And this one is the form for the affidavit, sort of just a general form. There isn't a specific form for property proceedings, it's just the affidavit. Affidavits can be quite time-consuming, and we sort of have a little look at them here. It's the client's evidence, as we know. It needs to be sworn or affirmed, should only contain factual and relevant information, must be to the point. And then we've got some formatting there. I'm speeding up a little bit because I am sort of running a little bit slow. So we've got an example of an affidavit here that we run through with clients as well, just to give them a bit of an idea of what their affidavit could look like. So they're covering the general sort of information, when the relationship started, that sort of thing. And then here you can see they've started using the headings, and that can be really helpful for, for clients and for lawyers, because with property settlements there can be a whole lot of information in the affidavit, and it can be really helpful to break it up into sections. With the clients, we have a little look at, what's wrong with the affidavit. And so you can see here in the red, it's all of the sort of inflammatory and opinionated comments, which aren't really facts, sort of saying he was an idiot and he sold them. So we sort of look at, with clients what they can and can't include in affidavits. So for the first part there, I mean, it's not entirely relevant because those assets are gone. It happened before the relationship anyway. For another thing, she's calling him an idiot and other silly things, which isn't really, try to keep it to the point. Down the bottom in number 5, you've got again those comments about him being useless and lazy and how his mother used to do everything for him. Yeah, it's not really that relevant. It's not going to make your client look good. Yeah, it's just not really helpful at all. Number 6 is interesting, and we sometimes use that for a discussion with clients about, hearsay, because on the one hand, this is the wife telling the client that this is what he's been doing, but at the same time, gambling and losing large amounts of money, like we looked at briefly yesterday, can be, under that sort of wastage consideration of that. So it could be, if that's all that the client has, maybe they can include it, especially if it's them drafting it and not a lawyer. And it's just, maybe if that's all you've got, put it in there, but just be really mindful of the fact that, technically, sure, from the rules of evidence, if it goes down to a trial, that might get knocked out of the affidavit. So, you'd want to maybe start actually finding some other forms of evidence about that gambling, which hopefully, there would be some if it was such an extreme problem. Fingers crossed. All right, so now with filing the court documents. We've just got information there. So you file them with the Family Court of WA Registry, which is located in Perth. You can do it in person or you can do it by post. If you're doing it by post, you attach a cover letter so that the court actually knows what they've got. Usually I recommend that clients file in person if possible, and that's because particularly if the client's sort of doing their own documents, they might then be made aware of issues at the court while they're there filing, rather than needing to, wait for those to get posted there, wait for them to get posted back, and then finding out that, it's been a week or two now with the delayed post system and you still haven't got that application into court. So it's just sort of safer to do in person if they can. A lot of clients that come in to see, lawyers for advice, they might have attempted the documents themselves and then they've got that requisition sent back and now they've decided, they can't do it themselves. And it's really nice that they have, made that attempt to do it, but if it's been unsuccessful, yeah, they might stop by and see you or see another lawyer for a bit of help about what's wrong. And in those situations, the requisition letter can be pretty helpful because it does set out in detail what is wrong with the application. But having said that, it can be worth having a little look at it yourself, and by that I mean all of the documents that the client will be filing, because there's, possibly something that's been not put in the requisition letter that, is not really on point. So for me recently that was, the client was filing some documents, some forms that they didn't actually need to file to achieve what they wanted to achieve. So we just we pulled those out and sort of fiddled around with the remainder so that it was nice and clean like the requisition letter said. But some of the changes didn't need to be made because the forms weren't even necessary in the first place. The client didn't need to file them. So it's just worth, having a little look at it yourself while you're at it. Here we've got the court fees. So as you can see, the initiating application and the response are both $330 each. So the applicant pays $330, the respondent pays $330. They can be exempt from that, which means that they don't pay any fee if they've got financial hardship or a concession card, which is a lot of clients for our service. The application for consent orders is cheaper. It sort of obviously goes through a bit faster if it's all done properly, and that's $160. But they're only exempt where both of them qualify for the exemption. Otherwise, they're going to have to pay it. The divorce application, as you can see up the top there, that's not, you can't be exempt from that entirely. The party is still going to have to pay the reduced fee, which is $290. And you've got the conciliation conference listing fee there, which I think I go through a bit later. But then you've also got the fixing of the trial date with the magistrate and the judge. So you can see that the magistrate's cheaper, the judge is more expensive. The magistrate tends to deal with the more simple issues, and the more complex issues go to the judge. The magistrate track would usually be listed a bit faster, whereas you would wait longer for a trial before a judge. So a lot of the time people are going to want to be before the magistrate so that it gets done quickly and so that it's maybe a bit cheaper. But that's not always possible, like I said. It's to do with the matter itself and how complex it is. So serving filed documents. A lot of clients do run into issues with service, and especially where the other party hasn't been cooperating with the pre-action procedures. They're trying to make the client's life more difficult, or there's issues of family and domestic violence. So one of the parties, sometimes not the party that I'm seeing, is keeping their address secret and is refusing to tell the other person. Or possibly in situations of drug use, you've got people who move around a whole lot. And they don't have a fixed address at all. So that can make it really hard to sort out the service. There's a service kit on the Family Court of WA website that explains how service works and how the client can do it, and it is actually really helpful. A lot of the time, clients' questions can be answered just through the kit, so it's a really helpful resource for that. The one thing about the service kit that I've always thought is kind of interesting is that it talks about if you can't serve the other party, you might need to apply for dispensation of service. Whereas I guess the first step that I would be looking at with a client would be whether they can apply for substituted service. Maybe this person doesn't have a fixed address, but they've got an email, or they visit their mum every weekend. That sort of thing, as sort of an approach before just going for dispensation, which I feel is probably going to be a bit of a higher bar to meet. So responding to an application, very similar documents to the application. You've got the Form 1A, which is the response, Form 13 for your client, and an affidavit in support. That's a nice little diagram of what the process looks like once you've filed the application. First off, you've got a procedural hearing, and it's something that can also freak out a lot of clients. If they've suddenly been served with documents for, court, they're really worried that, if they show up on that day, that the court's just going to suddenly finalise everything, and that'll be it, done and dusted on the day, and they'll get a result that they don't want. And the system definitely doesn't work that quickly. So the first court date's just procedural. The court wants to make sure that the respondent has actually been served, and check that disclosure has been done and that sort of thing. There can be more than one procedural hearing, especially if there's issues around service. They're not going to just sort of push things forward if not everybody is aware that there's proceedings going on yet. So at the procedural hearings, they can still make those sort of interim orders around, substituted service, or around, just all sorts of procedural issues. Then we've got the conciliation conference there. So that's, I'm not sure if there's similar stuff in other states, but basically it's, it's sort of the conciliation process to try and see if the parties can come to the table and reach an agreement, which, like I said, with, parties where there hasn't been any negotiation because one party's just been ignoring the other, that can be really helpful because now they both have to come to this conference, sit down and actually talk about it, and that can be really constructive. But that's, it's ordered in some cases and it's decided that that should be listed, but in other cases the court might decide that there's really no point in making a conciliation conference. It's unlikely to help resolve the matter. So I guess it depends on the issues that are going on. Then you've got the readiness hearing, making sure that everyone is ready for trial. You've got the call over dates, so making sure that, how long is this case going to take, how many days do we need, and allocating an actual date for the trial. And then you've got the actual trial date. And as I said before, that can be, something before a judge or a magistrate. Judge if it's, one of the more complex issues, which will take much longer to actually get the listing date. And these are some really nice etiquette points that we give to clients. I think, most of us are lawyers, so we're probably okay, but they're there just in case anyone wants to look later. We've also got the courtroom layout, so this is a cute diagram that we show clients so that they know, who's who in the courtroom, where they're going to be standing, and that sort of thing. Sometimes, I also recommend to clients if they're unfamiliar with the system, which is, most of them, thankfully for them, they go in on a different day to their day, you know, before they've got caught, and just, you know, ask if they can go in and have a little look at some of the other proceedings that are going on, even if it's just, you know, one or two things that are called up, just so that they've got an idea of, you know, what things will look like and, you know, how quickly people are called up and sent away and that sort of thing. Oh, and here we've got injunctions. So this is a bit of a big topic. So people were asking about situations where you might need to get injunctions. So if someone has been disposing of the property, or I've decided to go for exclusive occupation as well. So we've got a couple of examples here where your client might need to apply for orders to stop the other party from taking certain actions. And obviously injunctions can be quite broad, so it can be for a range of reasons, it can do a range of things, and it can be either to stop someone from doing something or to force them to do something else. But here we've got the example of A, she's been caring for the children at home, B has been working, A moved out after separation, took the children, the family home is in B's name, and A noticed the family home has been recently listed online for sale. Then we've got B, where C and D have separated, they're both still living in the family home together, C cares for the children, D works, D is refusing to move out because D says D was the one paying the mortgage, so D should get to say. D is getting more and more aggressive towards C because they're trying to force C to make that decision to move out. So for A, B in this situation is sort of starting to deal with property that should really be, you know, held onto until the settlement, unless the parties have agreed to, you know, do something else with it ahead of time, and hopefully done that in a secure way, not just a vague, informal manner. So the concern for the clients here is usually that they're not on the title, so legally speaking the other party can sell the house and keep all the proceeds for themselves without involving the client at all. And as we discussed yesterday, it is possible that when you're later sorting out the settlement, A could make arguments around B needing to include the value of the house or the proceeds of sale as an add back, or consider it in steps 2 and 3. But then A is stuck arguing for that later, which is not ideal. A is going to need to get some evidence to support that, which again is not ideal. And particularly where the house is maybe the only significant asset and the rest of the settlement relates to the debts of the parties, B might take that money, put it towards his debts, and, you know, God knows, like a drug addiction or something, there's just so many issues going on for some people. B might then later, by the time A gets around to resolving all of this, B might not have any ability to return that amount to the asset pool. B might have no assets left, he's only got debts. So, that, I mean, what do? You can't order for B to pay A. I mean, you can, but enforcing that's going to be difficult because B doesn't have anything to give A and probably won't at any point in the future. So it's not an ideal situation. It's best to prevent it from happening in the first place if, you know, the client can see it coming. So the Family Court of WA can grant injunctions relating to the property, and I've got it down there at the bottom. So for marriage you've got section 114, for de factos you've got section 235A. Those are the different sections for injunctions. To actually get the injunction for preserving property, you're going to need to show the court that there's an existing or potential claim to an order altering property interests. So for example, that, you know, the party can get a property settlement possibly, and that there's a danger of that claim being defeated or prejudiced unless the injunction is granted. And yeah, as far as actually applying for one of those, I haven't done it myself. I do have a little bit of info on that in a second. Okay, and then we've got this other scenario. And so basically what C is wanting here is possibly to stay in the home with the children, and that would be an injunction for exclusive occupation of the family home by C. That might be something that C is interested in. That can be done in certain circumstances as well, so it's usually along the lines of, you know, protecting a party, looking at the conduct of the parties, the means and the needs of the parties to relocate, the needs of the children, and hardship to either party or child. It can be relevant that C doesn't have the financial means to relocate elsewhere. Who the registered owner of the property is doesn't matter, because, you know, again, it's property settlement, it's property of the relationship, and it should all sort of come together. With respect to the conduct of the parties that I mentioned a second ago, violence will be, you know, a significant concern, but just the fact that one party is kind of annoying is not really going to cut it, generally speaking. The party can apply for exclusive occupation even if they have already vacated the premises. But I guess from that perspective you'd have to be looking at, where are they living then? Because if you're saying it's about the financial means of C to relocate, if she's already relocated, then it's obviously within her financial means to do so. So yeah, so that could be relevant. The onus for that kind of injunction is going to be on the applicant. So if C wants exclusive occupation, C needs to be providing enough information and evidence around why that should be the case. So as far as actually applying for those injunctions, I have not done either myself before. If the matter is in the court, I would file a Form 2 application in a case with a supporting affidavit addressing those issues which I've really quickly just gone over. And that's sort of easier because it's already in the court. On the downside, if it's not already being dealt with through the court process, I would be filing an exemption from family dispute resolution form on the grounds of urgency with a letter to the duty registrar explaining the urgency, a Form 1 application with the interim orders being that an injunction is needed, and a really good affidavit to back all of that up. But again, it's not something that I've done personally before. All right, and so this is the Form 2, so what I just said, if you've got a case already going on, you want to make an application within the case, this is the form that you use. To do an application in a case, you can't just file that form, you need an affidavit to support it. You also need a certificate of conferral, and that's available on the Family Court of WA website, just so that the Family Court knows that parties have actually tried to resolve this issue before one party has made the application. And once you make that application, the other party has a chance to respond to it. So that's how, you could end up having a bit of a real argument over whether exclusive occupation should happen or not. And again, all of the documents needed there are going to be on the Family Court of WA website. Okay, so we finally reached the end. So I'm sorry, I think I've gone a fair little bit over time, but I tried to rush it at the end there, so hopefully I haven't left anyone behind. So just a reminder again, at this point the client can still negotiate and settle with the other party at any point up until their trial. And if they do settle, then they should be coming and talking to you about doing some consent orders or trying to prepare those themselves, not just sort of wandering off and leaving the proceedings to just sort of float along and the court really confused about what people are doing. Okay, so I think that's all from me, and now we can have some question time.
Terrific. Thanks, Caris. Incredibly practical. Yeah, another really great presentation and a really great compliment to the session that you ran yesterday. A reminder that people can ask questions by typing a question into the questions box or pressing that button that looks like a hand, and some are starting to come through. I'd also remind West Australian practitioners working in community legal centres that this session has been approved for your CPD points. In other states and territories it's kind of a self-regulated process, but in WA there's a bit more structure around it. So if you are working in a CLC, get in touch with the CLC Association of WA for that. Some questions starting to come through, Caris, and we've probably only got time for one or two because that was a pretty action-packed session.
Yeah, sorry about that.
No, there was lots to get through, so thanks for doing that. One question that's come through, and it probably goes more to the content yesterday that kind of overflowed into today around windfalls, and that's pending inheritances. How might a party disclose pending inheritance, and how might that inform your four-step process around ascertaining the property pool which is to be settled?
That's a good one. I didn't look at that so much. Maybe, I mean, just off the top of my head, maybe, in step 3 when you're looking at the future needs, you've got the sort of future resources that the parties might have access to. So I'd say if there's sort of an inheritance coming up, and I think I read something along those lines which was basically, it's kind of hard to be sure that there's an inheritance coming up unless someone has an unfortunate terminal illness, which is very clear-cut. So maybe in that kind of situation, then it's pretty clear that that's going to happen and that party's going to get that inheritance. So yeah, I mean, I guess I don't really know for sure, but that's just something I read along those lines, and then I guess it would be about showing that they are going to get that. Yeah.
Terrific, thank you. There's another one here, and Sue, I'm not sure if I'm interpreting what you've typed right here, so feel free to correct me. A question around if a partner remains in the home and refuses the other partner, who's no longer in the home, access to the home to collect possessions and or documents that might be required through this process, what rights might the person who is being refused access to the home have to get in and get what they need?
Yeah, that's sort of not too uncommon for our clients either. And I guess, I mean, from my perspective, a lot of the time it sort of comes down to that practicality. Like maybe the client, depending upon the position, you know, could try to go for exclusive possession, exclusive occupation, like I ran through with the injunction. But if they've got the means to sort of be somewhere else, then sometimes it's just a matter of being somewhere else. And then when they start the proceedings, possibly asking for an order that, you know, those specific items be returned to them. Because short of, you know, those court orders making the other party do that, if they've physically been locked out of the house, you know, there's not really anything else in the law that's legally forcing anyone to let them into that house. And we see that sort of with people changing the locks and that sort of thing, especially with domestic violence. You know, she goes away to the refuge with the child and tries to come back to the house, and he's changed all the locks.
So I hope that answers your question. I apologise if your question was lost in translation by me there. We have gone over time, so Sue said that was exactly what she was looking for, so thanks, Caris. Can I, on behalf of everyone who's tuned in for both episodes of this mini-series, thank you, Caris, for a really practical and thorough oversight and introduction to property settlement stuff. Thanks to those people that are punching in thank you messages through the chat function too. Clearly it was really useful to a lot of people, so thank you, Caris, and thanks to your colleagues at Peel. Thanks everybody who tuned in. As I said, we hope to have a recording of this available and we'll circulate as soon as we can. Otherwise, look forward to speaking to you at another webinar soon. Thanks and good afternoon.
Thanks, James.